Today, we're diving into something really fascinating: judicial activism in India. We're going to explore how the Supreme Court walks this razor-thin line between just interpreting the law and actually shaping the nation's destiny. The big question is, are they a guardian of the people, or have they become a kind of unelected governor? Let's get into it.
This idea right here, from Justice V.R. Krishna Iyer, really gets to the heart of what we're talking about. It's such a powerful thought. It signals this huge shift, the idea that the country's highest court isn't just some abstract legal body, but a living, breathing thing that's there to serve its citizens directly. And you know what? This single philosophy really set the stage for a massive transformation in Indian law.
All right, here's our game plan. We'll kick things off by defining what judicial activism actually is. Then we're going to trace its history in India, look at the really cool tools the court came up with, and see how one of its biggest ideas literally went global. And finally, we'll jump right into the main debate. Where does activism stop and overreach start?
Okay, so before we get into all the history and the controversy, let's make sure we're all on the same page about what judicial activism even means. At its very core, it's about a judge shifting from being a passive interpreter of the law to an active innovator.
So, to put it simply, judicial activism is when courts do more than just apply the law exactly as it's written. They take a more creative, more dynamic approach. They look at the spirit of the Constitution, not just the literal words, all to protect citizens, fill in the gaps where the government might have dropped the ball, and make sure justice keeps up with the needs of a changing society.
This little comparison really lays it all out. On the one hand, you've got judicial restraint. Judges stick to the script, they read the law literally, and they defer to the elected government. But on the other hand, you've got judicial activism, a much more proactive approach, where the court steps in to make sure justice is served, seeing itself as an equal player in the whole system of government.
So how in the world did India's Supreme Court, which, by the way, started out as a pretty restrained, very British-style institution, turn into one of the most activist courts on the planet? Well, it turns out a major national crisis was the spark that lit the fire.
You can really see the court's journey happen in three distinct phases. After a pretty cautious start, the real turning point was the emergency from 1975 to 77. During that period of authoritarian rule, the court's credibility just got shattered because people felt it failed to protect their basic freedoms. So in response to that crisis, the judiciary basically reinvented itself. It went from being a passive umpire to an active crusader for the people, all in an effort to win back their trust.
All right, so with this brand new mission to be a court of the Indians, the judiciary quickly figured out it couldn't just stick to the old rigid way of doing things. It needed some fresh, innovative tools to make justice something that every single citizen could actually access, especially the folks on the margins.
And the single most important innovation? It was something called public interest litigation, or PILE. And let me tell you, this was an absolute game changer. It totally flipped the script on the relationship between the people and the courts. It was like throwing the courthouse doors wide open to anyone who had a genuine public concern.
The court pulled this off in three really revolutionary ways. First, it relaxed this legal rule called locus standing, which basically meant you didn't have to be the direct victim anymore to file a case. An activist could now sue on behalf of a whole community. Second, through something called epistolary jurisdiction, the court could treat a simple letter or even a newspaper article as a formal petition. All of a sudden, you didn't need a fancy, expensive lawyer to get your case heard by the Supreme Court. And finally, the court started issuing active remedies, meaning it would actually monitor the government to make sure its orders were carried out.
Now, what's so incredible is that this era of activism didn't just change India. One of its most powerful ideas, one that was born out of a huge fight between the judiciary and the government, actually ended up influencing constitutional law all over the world. And that big idea was the basic structure doctrine. In this landmark case of Ananda Bharati, the Supreme Court made a truly revolutionary statement. It said, look, Parliament can amend the Constitution, sure, but it can't destroy its fundamental identity. Core principles like democracy, the rule of law, and the independence of the courts were now off limits. It was basically a brilliant judicial move to protect democracy from being taken apart from the inside by a powerful government.
And the influence of this Indian idea really did go global. Now, Germany had something similar called an eternity clause after World War II, but countries like Bangladesh directly adopted India's doctrine to guard against authoritarianism. Courts in Kenya used similar logic to protect their own constitution. It really became a new standard for how courts could defend democracy worldwide.
So,
All of this brings us to the central conflict, the big debate that's still going on today. When does a court's creative interpretation cross that line from being necessary activism into dangerous judicial overreach? This is the great debate.
So on one side, you have people who argue that activism is a vital safeguard for democracy. They see it as absolutely necessary to limit government power, to improve accountability, and to expand our rights to cover modern issues, like the right to a clean environment. From their point of view, when elected leaders don't act, the judiciary has a duty to step in and fill that void.
But then, the critics have a really powerful counterargument. They warn that this is a slippery slope, that it could lead to a kind of judicial tyranny. I mean, when unelected judges start making policy decisions, everything from banning firecrackers to managing city planning, they're essentially overriding the will of the people's elected representatives. This, they argue, completely blurs the separation of powers, it can create chaos in government, and it gives a huge amount of power to judges who, let's face it, aren't accountable to us at the ballot box.
At the end of the day, this isn't a debate with a simple right or wrong answer. What it really represents is an enduring and maybe even a necessary tension right at the heart of modern democracy, that constant search for a delicate balance between the different branches of government.
And this quote from former Chief Justice J.S. Verma just captures that balancing act perfectly. He says the judiciary's role is to be a sentinel on the qui-vive, which means a vigilant guard, always watchful. It has to be active enough to protect people's rights, but also humble enough not to take over the job of governing. That job, he says, belongs to the elected branches.
And that leaves us with this huge fundamental question. It's the core dilemma of judicial activism. In a democracy, who gets the final say? Is it the lawmakers we elect and can vote out, who represent the will of the majority? Or is it the judges we don't elect, whose job it is to protect the constitutional principles that shield everyone, especially minorities, from that very same majority? There really is no simple answer, and how a nation chooses to grapple with this question, well, that defines the very character of its democracy.